Hello, hello, and greetings to all the listeners. We are glad to welcome you at our discussion on the topic of arbitration of corporate disputes. My name is Aliaksei Vashkevich. I'm a senior associate at Raul law firm, and I will be moderating this event for you today. Together with me are my wonderful colleagues who will be sharing the knowledge with you. They're all members of Saranian Dispute Resolution and Risk Management Practice Group, and each of them represents one of our Baltic countries. Let me introduce them all. Starting with Lithuania, we have Counsel Ieva Rimavičienė, shedding some light on local practice of arbitration of corporate disputes. Next, we have Senior Associate Raul Kartsep, who will be sharing Estonian perspective on arbitration of corporate disputes. And last but not least, partner Valts Nerets, co-head of the Dispute Resolution and Risk Management Practice Group, who will be speaking about Latvia. Thank you, colleagues, for joining. Now, we will be shortly starting our discussion, so get some coffee or the beverages, get comfortable in chairs wherever you are, whether at home or at your office. Luckily, we all live in post-COVID times, and it is much easier now to participate in online events or work from whatever remotely. Jamie, before we begin, I have a couple of housekeeping remarks to make. Firstly, this event is recorded. We will share the recording afterwards with you, and it also will be available on Saranian YouTube channel. Secondly, there will be some time allocated for your questions closer to the end of the event. So please feel free to post your questions during our discussion using the Q&A window. Okay, that's all with the announcements. Now, arbitration of corporate disputes. It's definitely not one of the topics that you usually hear about here in this lovely but a bit too rainy part of Europe. And it's quite remarkable, especially if to compare the Baltics with some other jurisdictions, even closer ones like Poland or Germany, where this topic seems to be more usual and familiar for the audience. At least in my personal experience, when observing lawyers from those jurisdictions, I see on the, for example, LinkedIn pages, how they post information about the recent corporate arbitration cases, articles on the questions, or even big conferences. And it actually made me wonder, why don't I see the same in the Baltics? Is it an issue with the size of the local economies? Or maybe I'm missing some discussion in Estonian, Latvian, or Lithuanian. Thankfully, I do not wait until I learned one of those languages at a decent level, because I have my colleagues who definitely have actual knowledge about the local practices. In this respect, Ieva, would you mind to start and tell us a bit about corporate disputes in Lithuania? Is arbitration actually used to resolve them?
Yes, Aliaksei, thank you so much for your kind introduction. The answer to this question very much depends on what we actually consider as the corporate dispute. My personal opinion, of course, based on the case law and doctrine in Lithuania, is that there are four main dispute categories that fall under the corporate dispute concept. So we have SPA disputes, we have shareholder disputes, we have disputes between the company and its manager, and the disputes concerning management bodies' decisions. In Lithuania, from my experience, the first two categories of disputes raises the least of questions and uncertainties and are currently being more often than not referred to arbitration, I would say. At least when we talk about the bigger companies with more international experience, when we prepare SPA agreements or shareholder agreements, most of the time we include arbitration clauses there. However, the other two categories, meaning disputes between the company and its manager and disputes concerning management bodies' decisions, are quite rarely referred to arbitration. This might be caused by uncertainties associated with these types of disputes and their arbitrability, which we will touch upon a bit later, I think. And since I consider myself to be a person of numbers, I would like to shortly overview some statistic which illustrates the current situation in Lithuania. I would like to start from the core statistics. So in 2022, in first instance court, there were more than 2,500 cases related to activities of legal entities, all in all. Out of this number, we have 457 cases concerning management bodies' decisions, and we have 23 shareholder disputes there. On the other hand, we have statistics, for example, from the local institution, Vilnius Court of Commercial Arbitration. Of course, the statistics is based on economic sectors, therefore we cannot identify exactly how many disputes, shareholder disputes or disputes concerning management bodies' decisions are there, but we have a total numbers. So the total numbers, depending on the year, varies from 25 to 27 cases, sometimes reaches almost 30 cases. But what these numbers reflect actually is a huge potential of more corporate disputes being referred to arbitration in general. And I think this potential is still not yet used up in Lithuania. And therefore the topic calls for these discussions and also developments both in legal acts and case law in Lithuania.
Thank you, Ieva. Now, Raul, what about Latvia? Is the situation similar there? Oh, sorry, not Latvia, Estonia.
Absolutely. Greetings, everybody, from rainy Tallinn, rainy and gray Tallinn. But for that time of the year, it's kind of normal. Coming to the question, generally speaking, I don't think that arbitrating corporate disputes is very popular in Estonia. I looked at the statistics, and as Ieva mentioned, there are all the same topics: shareholders, share purchase agreements, company management disputes, and management body decisions. They all could be theoretically arbitrated, but our statistics show that in Estonia, mostly arbitration is related to the shareholders and share purchase agreements. I did not find any case law over having corporate disputes with respect to challenging the resolutions of company bodies. And I think there's a reason for that, which we likely come back later. But just to give you a context of what Estonian arbitration market is that in the most popular arbitration institute which we have in Estonia, Court of Arbitration of Civil and Chamber and Industry, there are on average there are 10 cases per year, which is very few compared to the state court practice. And some years less, some years more, but on average 10 per year. And most of them consider contracts of sale or contracts of services and not corporate stuff. However, as said, some corporate issues are still being arbitrated. But this does not mean that Estonia is not a pro-arbitration country. What I'm gathering from it and what we've seen from practice as well is that we just have very good competitors in terms of arbitration institutes. Many disputes in our region are forwarded to the Stockholm arbitration or to the Helsinki arbitration or even Vilnius from Estonia. So it's just that the Estonian arbitration court itself is not very popular these days. But I will give a brief examples of why we could use Estonian arbitration more in the next upcoming an hour. I think that's it for me right now. Thank you.
Yes, thank you, Raul. Valts, and how do you feel?
Well, thank you, first of all, for inviting me to this discussion. I'm always happy to speak about arbitration because not only I'm doing arbitration-related disputes daily, but also I'm sitting as an arbitrator myself. So I have also some insider knowledge, so to say, from the institution perspective. And whenever I'm talking about for an international audience about arbitration in Latvia, it always feels like doing a stand-up, because actually it is like telling a joke or an anecdote, because it was exactly 10 years ago in November 2013 when we counted 214 institution arbitration courts in Latvia. Because of the very liberal regime that we had since the 1990s, indeed, the number of arbitration courts was ridiculous. Then in 2021, the number already dropped to 68, which is still, I mean, huge in comparison with what we have in Estonia and Lithuania. And currently, we just counted some days ago, the number of arbitration courts in Latvia is 57. Still, can you imagine 57 institutional arbitration courts in a country of about 2 million people? So quite many of these arbitration courts still exist, like formally or as a pocket arbitration courts, unfortunately, meaning for resolving of disputes, or hopefully not, but they are created by legal persons, companies of limited liability, mostly for resolving their own disputes, where one of the parties is mostly is this legal entity, which is not how the arbitration should work in general. And obviously, this overall picture has pretty much distorted the public's perception about arbitration as means of dispute resolution. And generally, the public trust in arbitration is very low. So to answer Aliaksei's question, I would say that generally arbitration is not popular in Latvia at all for resolving of disputes. But step by step, we are making these baby steps in the society, also explaining how the best of these 57 arbitration courts work, and why they are impartial and why they should be chosen for resolving of disputes. Because of the many advantages that we will also cover in this discussion, which absolutely arbitration has, and I'm 100% in favor of arbitrating disputes instead of litigating disputes. When it comes to corporate disputes, from the categories that Ieva mentioned, I can also tell you that what I have seen is mostly post-M&A disputes being arbitrated in Latvia. And these would be disputes between Latvian entities, because Latvia, for its arbitration law and very awkward regime, is typically not chosen as a seat for international arbitration. But we have very progressive law amendments that I will tell you about later on, and hopefully that Latvia will become more popular for becoming a seat also for international arbitration. So post-M&A disputes and shareholder disputes, disputes between shareholders and companies, I can tell you that, well, the law doesn't prohibit these disputes from being arbitrated directly, expressis verbis, so to say. So I would say that these disputes should be arbitrable when it comes to management body decisions. I would be more skeptical, same as Ieva mentioned, and I think Raul, you said that too. So overall, I think but there's no court practice. We end up there that there must be someone first to go and arbitrate. But of course, it starts with putting the right clauses in the right documents, isn't it? So, but yeah, thanks for Latvia. That's it for now.
Thank you, Valts. You mentioned that arbitration practice is gradually developing, but let me ask our speakers the next question. Is it actually worth to develop it? Is it actually a good method for resolving corporate disputes? Raul, what are your thoughts?
Thank you. When thinking about the question whether arbitration is a good method to resolve corporate disputes, well, the first thing that comes to my mind is to determine what's important for corporate or company shareholders in resolvement of disputes, and usually it's speedy proceedings. No one wants to stop their everyday doings because of some disputes, and confidentiality is very often important for shareholders. And I think it very much aligns with what arbitration has to offer, because usually, and I believe it aligns in all Baltic states, the arbitration, like 3 most beneficial things are considered speedy proceedings, confidential proceedings, and flexibility, which the parties could get from arbitration. And I'm not going to get into the details with everything, and I believe my colleagues can later comment that further, but I would like to touch upon a couple of things that how Estonian law stands out in terms of these benefits. And what's very interesting about Estonian law in terms of speedy proceedings is that the awards or the decisions of our local arbitration institute are directly enforceable under the law. And this means that on the same date you receive the arbitration award, you can go directly to the enforcement officer, start arresting other parties' funds, or seize their property, look for settlement. And this quite greatly differs from many other jurisdictions that I'm aware of. And it also differs from state court practice, because in state courts, you need to wait for at least 30 days in order for the judgment to get in force. Whereas in arbitration, the award will be in force and final on the same day it is issued. And it differs very much and gives benefit in terms of speediness. Another thing that I wanted to comment on is confidentiality. And under Estonian law, arbitration is by default confidential in all aspects. And what I mean by that is the tribunal of arbitration could, in some cases, need help or assistance from state courts. Let's say a party claiming in arbitration wants to seize other parties' assets to secure its claim. And in that sense, the arbitral tribunal will turn to the state court looking for relevant ruling. And in these kind of situations where arbitral tribunal needs help from state courts, is by default under Estonian law confidential. And I'm not really sure whether it's the same in Lithuania or Latvia, but I know for a fact that in Sweden, by default, the arbitration is not supported with confidential state court proceedings, and that way Estonia differs. This said, if someone asks me what are the cases when I would recommend my client to consider arbitration, two things comes to my mind. First is if you have a multinational or multilingual issue, then it's more flexible and easy to turn your dispute to the arbitration, because you don't need to work with interpreters, like translate everything. You don't need to do that as you need in Estonian courts. And also, as I just said, speedy and confidential dispute resolution. Thank you from my end for now.
Yes. But do you agree with Raul? Is arbitration also a faster and more efficient way to resolve corporate disputes in Latvia?
Yes. Well, generally, of course, I agree with what Raul said about the confidentiality and speed as the main advantages of arbitration proceedings. Regarding speed, I can give you just an example that in Latvia nowadays, the appellate court, so the second level court, it's scheduled hearings. So we received this information in July that the hearing is scheduled in February 2025. So it's 19 months of waiting until you get your court hearing in the appellate instance court in Riga, which is the most, of course, popular court for most popular second instance court. But this just gives you an idea about how much you have to wait. In the first instance court, the average waiting time, I don't know, can be from a couple of months until up to 1 year, which still is quite a lot. Because we can discuss the average timing later on. But to continue with the pros and cons of arbitration in general, for corporate disputes, for example, I would mention the arbitrator, the option to choose an arbitrator who is a professional, who knows something about corporate disputes, right? Because of course, judge has the legal education, everything in place, and he's a qualified lawyer. But still, when it comes to corporate disputes, I wouldn't expect the judge to understand what reps and warranties are and how they work, what a closing actually means in an M&A deal. And of course, you can try to explain all this to the judge, but if he or she has never worked with an M&A deal or with any other corporate matter, it's more complicated to explain your case and get your award right, what you actually expect from the court to understand from your case. Of course, with arbitration and international arbitration, what you can actually choose an arbitrator who is experienced in disputes and post-elimination disputes, or actually who has closed hundreds perhaps or even more deals themselves. It's a completely different picture. And then you can expect that there are no, so to say, surprises, unpleasant surprises at the end, because you have, of course, spent your time and you have invested your money. I wouldn't say, well, actually, when it comes to arbitration, our clients do not consider this cost as an investment, because you're just spending money. You're not buying anything, you're not acquiring any asset. So for the clients, it's just expenditure. It's the cost part, the ugly part. And if you have indeed put that much effort into arbitration of a corporate dispute, which of course involves your very important asset, your company likely, then you of course expect a result that you can enforce at the end, and which is an enforceable, rightly drafted arbitral award. And that is what you can expect from a professional arbitrator, including in Latvia. I hope the professionals in most of the Latvian arbitration courts, meaning attorneys at law mostly, are capable of doing. But this option that you can actually choose who hears your case, I think it's a huge advantage. Thanks.
Ieva, and what is your perspective? Would you recommend arbitration to your clients?
I would totally agree with what Raul and Valts already said, and to illustrate the importance of picking the right arbitrators. I would like to tell one story just that came into my mind. My colleague just told the story when in the court proceedings, the court asked whether EBITDA should be included as the third person into the proceedings. So, of course, this is an exception and funny story, but I don't know if it's still that funny when you have post-M&A dispute in court. So, yeah, this is very, very, very important. And as we say, that arbitration is as good as the arbitrators are. So this is the main thing. Also, adding on other features of arbitration that I would say are, at least from my perspective, most important for the businesses when choosing whether to refer their dispute to arbitration or not, is of course confidentiality, as Raul mentioned. So in Lithuania, the situation is that law on commercial arbitration indicates that arbitration is by default confidential. So all the documents, the parties, the fact of the dispute is not being dragged through media, not being discussed, etc. In comparison, we have litigation proceedings where the general rule is that the process is public, and only rare exceptions to that rule. So this is, I think, this cannot be expressed in money. So the confidentiality most of the time is very important to business. It helps to secure the reputation and also any commercial secrets that are being discussed in the process. So this is the second thing that I think, from my opinion, is very important in choosing the arbitration. And the third one, I would say time and cost. Because from one thing is that when you compare the cost of arbitration in one instance, it's not you cannot have appeal. You can have, like in certain cases, you can have annulment or recognition process, but in general, you don't have the instance system. So in Vilnius Court of Commercial Arbitration, the average duration of the processes of arbitration process is something around 8 months. In comparison, we have statistics from court where we have 6.5 months in first instance, then around 6 months in the appeal, and almost a year in Supreme Court. However, these statistics, I would say, would not reflect the actual situations. It's when we consider the more complex cases, this would definitely be longer. And from my experience, it's around a year and a half in first instance, around a year in the appeal, and yes, around a year in Supreme Court. So when you compare all the costs in arbitration in 8 months and all the costs in 3 or a year or more, so this actually, I think, shows very well that it might not be very much cheaper, but at least it will go to the same level. Another thing that should be considered when you go to litigation process in Lithuania, that even if you win in all 3 instances, you will not be able to recover all your litigation costs. There are certain recommendations, there are certain numbers indicated there, and court would not go above. So basically, these recommendations does not reflect the actual situation in the market. So basically, even if you win, you lose a lot of money in the process. In comparison, in arbitration, in normal circumstances, more or less, you get the winning party gets it all. So I think that's also what is important to have in mind.
It seems that in all of our 3 Baltic countries, arbitration indeed can offer significant advantages in terms of expertise of the arbitrators, costs, efficiency, and confidentiality. But still, we have the numbers. We do not have so many arbitrations in practice. You were all mentioning some arbitrations of M&A disputes based on shareholders' agreements. But what about other corporate disputes? Disputes within the company, for example, about challenge of shareholder resolutions, dismissal of management. Are they present in practice? And if no, why? Valts, could you tell us a bit about that with respect to Latvia?
Yes, thank you indeed. And I will try to explain how I think this should be done, because of course there is almost non-existent court practice in Latvia regarding in this respect. As you mentioned, post-M&A disputes, I think there shouldn't be any doubt that they must be arbitrable, and we have seen them also being arbitrable in the international arbitration, and these awards are absolutely recognized and enforced later on in Latvia, for example, under Article 5 New York Convention, meaning that there are no grounds to refuse enforcement. And under Article 5, Part 2, Paragraph A, there's this provision whether the dispute itself, the subject matter, is arbitrable in the country where you seek enforcement, which means in affirmative that in Latvia post-M&A disputes are absolutely arbitrable. If you ask me, I would say that intra-company disputes must be absolutely arbitrable, and shareholder disputes among shareholders must be also arbitrable. I didn't see any explicit or implicit prohibition in the commercial law or the arbitration law as such. When it comes to disputes with management, I would put it that way, that the law absolutely prohibits employment disputes from being arbitrated. Therefore, unless you have an employment agreement with your CEO or your director or anyone, but this is other type of contract, which is not employment, so you don't have an employment relationship, these disputes should be arbitrable. And actually, it makes sense that they are arbitrable because of the speed and other advantages that we discussed before. And when it comes to compensating losses from management board, for example, for fraud or for acting in bad faith or anything else, actually it should be arbitration that resolves these kind of disputes because of the advantages we mentioned before. And but however, when it comes to disputes involving more public element, like, well, for example, insolvency would be a clearly no-go, or liquidation of a company or anything like that would be not arbitrable, although we can just derive this conclusion from our general understanding how the law should work, because there is no specific prohibition of, for example, to arbitrate shareholders' decisions on something. But to be on the safe side, currently, how the Latin law operates, I would say that shareholder decisions wouldn't be arbitrable, but they would be in the competence of the state court. And currently, we have the Court of Economic Affairs who is competent to hear these type of disputes. So we have actually a specialized court for these type of disputes. Yeah, thank you.
It's great to hear. And Ieva, I remember from our previous discussions that you have an interesting specifics in Lithuania about arbitration of disputes with the management. Could you please share with us that?
Yes, of course. Thank you, Alexei. At first, I would like to begin, I think, from the framework, how it works in Lithuania. So the arbitrability question in Lithuania, at least it was intended to be based on favor arbitrandum principle, meaning that all the disputes are arbitrable unless the law of commercial arbitration explicitly provides otherwise. So we have the Article 12 of the law on commercial arbitration, and we have a clear sentence that all disputes may be settled by arbitration except as provided in this article. And then we have several categories of disputes which are either non-arbitrable or have certain conditions that have to be satisfied. So at first we have disputes which are non-arbitrable in any case. So there are, of course, which are subject to administrative procedure or fall under jurisdiction of constitutional court. Also, we have family matters which are non-arbitrable, and the disputes concerning registration of trademarks, designs, etc. So these disputes cannot be referred to arbitration in any case. The second group is the disputes that can be arbitrable, but the arbitration agreement has to be concluded after the dispute has arisen already. So to this category, the disputes, employment disputes and consumer disputes fall. So as you can imagine, when there's a requirement to conclude arbitration agreement after the dispute has arisen, naturally it results in not many disputes being resolved in arbitration of this kind. And also we have certain disputes where we need a prior consent of the to the arbitration agreement by the founder of state or municipal enterprise. So this is basically the framework of arbitrability of the disputes in Lithuania. And when we talk about corporate disputes, we see that they are, according to this list, they are not included in non-arbitrable list. Therefore, we could conclude that Article 12 allows us to refer these type of disputes to arbitration in general. However, currently the situation in Lithuania is not that simple, since the Supreme Court have chosen path of interpreting which disputes are non-arbitrable in a wider manner, stating that other legal acts, not the law on commercial arbitration, could also indicate certain disputes that would be considered as non-arbitrable. And the case law developed by determining certain additional disputes as being non-arbitrable and subject to exclusive jurisdiction of courts. So, for example, we have certain disputes arising from the public procurement relationship, non-arbitrable. Also, investigation into the activities of legal person is considered non-arbitrable. The good news here is that there is already some case law accepting intra-company disputes as being arbitrable in general. In this respect, it is then very important to have arbitration clause in place, which would meet the requirements indicated in the law. As to your question about the disputes with the manager, yeah, this is very important, I think, issue that I would like to touch upon. Some problematics arise there from the dualism of this legal status of the manager. In Lithuania, legal acts determine that the employment contract has to be concluded with the company's manager. On the other hand, the case law widely accepted the civil nature of the legal status of the manager. So why it is important, if we were to consider the basis of the relationship between with the manager being subject to employment law, then such a dispute could be resolved in arbitration only if the arbitration agreement is concluded, as I mentioned, after the dispute has already arisen. And this more or less means that these disputes would not be referred to arbitration. In comparison, if we recognize such relationship being purely civil, there would be no restrictions to settle such kind of disputes in arbitration. And from my perspective, the legal status of the manager is more civil one, and at least the disputes arising from breach of its fiduciary obligations to the company, its civil liability can be referred to arbitration. And this is reflected in most of international jurisdictions in other countries. So yeah, I think there's still a way for the case law to develop on this matter, but more or less it is already recognized that the civil nature of this relationship.
It looks that the basic approach to arbitrability under both Latvian and Lithuanian laws is quite broad. And what about Estonia, Raul?
Thank you, Aliaksei. I'm going to be quite short here because I think in Estonia, similarly as in Latvia and Lithuania, situation is more or less the same. Under Estonian law, everything is arbitrable unless explicitly prohibited by law, and these grounds, which are explicitly prohibited, are quite limited. And they are something related to public element. For instance, insolvency-related, liquidation-related issues are directly, explicitly directed to the state courts, not in arbitration. And disputes related to the property, which is registered in Estonian land registry, only the state courts could do that because they have access to this land registry. Simply put, but in order to have arbitration between shareholder or the manager and the company, you need to look for or put a valid arbitration clause into where can you put it. So the question arises, how can we privatize the corporate's disputes? And in that sense, I see, or how we advise our clients is first to put an arbitration clause into the shareholders agreement and into the management board member contracts. And you need to do this with all shareholders or managers in order to have the disputes in arbitration. With respect to the challenge of companies' resolutions, of company body resolutions, it's a difficult subject under Estonian law. When analyzing it, well, first of all, the law says that everything related to challenging corporate bodies' decisions, and corporate body, by a corporate body, I mean a general meeting of shareholders and management board members' decisions. So in order to challenge those, Estonian law says that there's an explicit or exclusive jurisdiction of state courts. However, at the same time, there's no limit in the arbitration law by saying that these disputes are not arbitrable. So I don't really see any reason for why I say that private company cannot privatize its disputes, but it's untested in courts. There's no case practice, and when I analyzed it yesterday, thinking about this question, I came to a German law example because Estonian law mostly comes from German law is German law based, and in Germany these disputes are could be done privately, could be done within arbitration. So I don't see. I'm quite comfortable arguing that in Estonia they can be done as well. Thank you.
Raul mentioned an issue with conclusion of arbitration agreement and ensuring that it's concluded between all the shareholders. And in this respect, many jurisdictions allow to add an arbitration clause to the Articles of Association. Is it possible in your countries? So, Ieva, what's about Lithuania?
Yes, this is an interesting question. So once again, starting from the basics, I would say. So the legal provisions requires that the arbitration clause should be in written form. So these are two requirements: a written form, either one document or exchanging separate documents, or even the reference to a separate document which indicates the arbitration clause. And also the second one is the clear intent of the party to refer disputes to arbitration instead of litigation. So from my perspective, the same applies to arbitration clause being included in Articles of Association. There is no prohibition to include arbitration clause in Lithuania in the Articles of Association in general. And this is even encouraged in the doctrine, I would say. However, the issue is whether the requirements, my indicated requirements of parties' consent is satisfied in this case. The case law, there's of course not much of case law, but there are several cases. They already provide for some guidance in this matter, putting clear emphasis on whether particular party to the dispute was aware and expressed its agreement to be bound by the arbitration clause provided for in the articles. And the Supreme Court established the intent of the party, that the intent of the party can also be expressed by concluding agreement, giving the reference to arbitration clause established in the Articles of Association. So basically, in this case, there was agreement giving reference to Articles of Association where this arbitration agreement was indicated, and the court agreed that the consent was expressed and the party did know and did agree with such kind of dispute resolution method. So I would say yes, there's no prohibition to include the arbitration agreement in Articles of Association according to Lithuanian law.
Valts, can businessmen in Latvia use the same very convenient method of concluding an arbitration agreement?
So on this topic, I'm happy that I can give a clear answer, which is no. On this, we have Latvian Supreme Court practice, which although dates back to 2007, but which still states that, well, basically the concept, one of the requirements for arbitration proceedings is arbitration agreement, meaning consent with an agreement in a specific form. And the Supreme Court concluded that Articles of Association doesn't form an arbitration agreement between the parties. Therefore, since there is no agreement, the dispute shouldn't be arbitrable at all. And well, the court went on to say and to conclude that Articles of Association is a company establishment document, and therefore it doesn't qualify as an agreement as such, where to insert the arbitration agreement of laws. And therefore, I think I would say that I would believe that nothing has changed since 2007, at least in Latvia, and I wouldn't recommend inserting arbitration clauses in Articles of Association. Of course, we could set up a company ourselves and include in the Articles of Association this clause, and then test how the court interprets it 15 years later. But currently, my answer is no.
And how could the clients actually then agree on such an arbitration agreement for corporate disputes? Can they put some provisions in their SPA agreements or shareholder agreements?
Yes, from the Latvian perspective, exactly. Whatever agreement you have, an SPA, shareholders agreement, whatever else agreement, there is the place for you to put an arbitration agreement. And we can discuss later on about tips and tricks, because I'm not sure if I would advise Latvian institutional arbitration court in your shareholders agreement, but we can come to that a bit later.
Sure. So there is some conceptual difference in the approach to arbitration clauses in Articles of Association between Latvia and Lithuania. And what about Estonia? Raul?
Thank you. Well, theoretically, yes, you could put an arbitration clause within the Articles of Associations. The law does not prohibit. However, in practice, and I did ask around within my colleagues who have been dealing with company law for, I don't know, 2 decades for the whole existence of Estonian law system, and no one has ever seen arbitration clause within the Articles of Associations. And I think there's a reason, or there's a very simple reason for that. It's just that parties do not intend to decide on any jurisdiction within the Articles of Association yet. There's no jurisdiction clause to the state courts either. There's simply nothing saying anything about the dispute resolution. And it, in practice, is just usually done within the shareholders' agreements or between the contracts between the related parties within the company. So shortly put, theoretically, we could do this. We would not advise it, and we have not seen any. Thank you.
Okay, thank you. Speaking about this lack of practice and sometimes not the most pro-arbitration court practice, as in the example of Latvia, if you were a legislator, would you change something in your local laws to actually make it more convenient to use arbitration to resolve all kinds of corporate disputes? Raul, would you please continue on that?
Absolutely. As I briefly began before, is that in generally speaking, Estonian law is very pro-arbitration. The law supports it. It supports the speediness. It supports the confidentiality. So there are no really big issues. When I started to think about if there's something which need a change, then it would relate to the corporate disputes. It would likely be the same thing that I discussed briefly before, that the legislator should decide whether we can privatize all business related issues. And by that, I mean that we should amend the law saying that challenging the corporate resolution bodies should also be allowed within the arbitration, and they are not only be held in the state courts. Other than that, I think our arbitration law currently is pretty good, even or especially considered to the bizarre situation in Latvia. So I'm happy that you guys are involving there, but nothing from my side further right now.
So, Raul, do I understand correctly that in Estonia it's more an issue of a mindset, and this more explicit statement is in the law would be just to give some comfort to business persons to use arbitration?
You are correct in assuming that, yes, absolutely. It's not that very commonly known among businessmen that arbitration could be used, and yes, a change in legislation could advertise arbitration more. So absolutely, yeah. This is also why we're having this short panel discussion to promote that there's alternative methods on how you could resolve your disputes within a company. Thank you.
Yes, definitely. Thank you a lot. Ieva, what about Lithuania?
Well, I think I touched upon several of the issues. I would agree with Raul. In Lithuania, there's also not many issues. We're also a very pro-arbitrational country, and the case law goes to that direction. But several things that I would improve, I would say. First of all, it would be good to, in order to manage expectations of the arbitration users, to have a clear and exhaustive list of non-arbitrable disputes. There shouldn't be the court practice narrowing or expanding this list on case-by-case basis, because, well, this causes a lot of uncertainty. The other thing, and this is implemented in at least several countries in Lithuania when I analyze the topic, is the clear in Europe, the clear indication in legal acts that the arbitration clause referring the disputes to arbitration can be established in the Articles of Association. Preferably, it could be included in the law and commercial arbitration or the company law, or even both. So this would actually would be the next step from the case law we have, and would definitely improve the situation. And the third thing I would say, the clear indication also in the legal acts that although we have the employment contract being concluded with the manager, the company and the manager may agree to refer to arbitration their disputes arising from performance of its fiduciary obligations and its civil liability towards the company, so that this is not in the scope of the employment sphere, and the separate agreement can be made to refer such disputes to arbitration.
Thank you, Ieva. Now, coming to Latvia, Valts, what would be your recommendations?
So about changing law so that it is more friendly to arbitrating corporate disputes, I would start with first that I'm glad, happy, and also relieved that Latvia has done its homework already regarding changes in the arbitration law in general. It took 9 years, but now we understand that the society has become more mature, and we have developed as a nation. And the wild 90s are gone, hopefully forever. And there is now a draft law in process, which is expected to be enforced as of March next year. So what this law says, this draft law says that Latvia is about to abolish the so-called wet ink requirement, because currently we have only the wet ink or secure electronic signature requirement, which just doesn't correspond to reality, how contracts are concluded in business nowadays in the EU, for example, or in the world in general. It's just not how it works anymore. So I'm so happy that we're going away from this. Then Latvia, I think, is the only country in the European Union which doesn't have the so-called set-aside procedure for arbitral awards. This is about to be corrected, and I'm very happy about that. Then additional provisions about the court involvement in arbitration proceedings, such as with collection of evidence, such as deciding objections regarding the arbitrators and other procedural aspects. This was also not governed in the arbitration law. Also, we're going away from the so-called closed list of arbitrators. Currently, each institutional arbitration court in Latvia must have a list of at least 10 arbitrators, and then when you're having a dispute in this arbitration court, you have to choose from that list. So you can imagine 10 arbitrators, it's not a lot, and most of them can be conflicted, and then what then? So, but we're going away from these closed lists. They would stay as a recommendation for arbitrators, but still the parties would be free to decide on arbitrator appointments. What else? Well, for example, currently the law doesn't allow witness statements, like oral witness statements, someone coming to the arbitration court hearing and speaking about what they know. So we're going away from this as well, because at least in international arbitration, fact witnesses are, well, crucial for defending your case. So this is about improving the arbitration law in general. Then I would say, and I would advise everyone to involve an attorney when you are either drafting a contract or you're having a dispute, but hopefully when you are drafting, because there are some issues which are not explicitly covered under law, but which are covered under the court practice. And well, I would just use this opportunity to say that, for example, and this case law is already 10 years old. Well, arbitration law says that about the arbitrability of disputes, that such disputes are not arbitrable, which parties of which are a state, a local municipality, institutions. And there is a huge debate time after time, and this question pops up now and then, whether a state-owned capital company, a limited liability company, which is state-owned, can be a party to arbitration proceedings, to local arbitration proceedings. And this question has been decided in affirmative. And therefore, if there are any representatives of state-owned capital companies, you are absolutely free to include arbitration clauses in your contracts. And there is nothing wrong with it, at least if you have the right arbitration court. And we can decide on this topic from different angles. But other than that, I would say that it would be, of course, very beneficial for the business if state could, at least expand the list of disputes which are arbitrable or not arbitrable to give more clarity in direct wording. Like these issues can be decided in the arbitration court or within the meaning of this law, we understand that court also means arbitration court, because there is also constitutional court judgments who say that references to court shouldn't mean references to arbitration court, and so on. So more clarity from the states, from the state in respect of which indeed are arbitrable or not, so that we do not do this guessing game. Because at the end, I mean, the clients would invest time and money, and at the end, if you get your award which is unenforceable, it just doesn't make any sense. So more clarity, I would be happy for that. Thank you.
Yes, it's great to hear about upcoming improvements to the Latvian law on arbitration, and it's also nice to hear that basically the main topic that all of our speakers were mentioning was not about some fundamental deficiencies of local laws, but mainly about improving clarity. So I hope some of our listeners will feel enthusiastic about trying arbitration and maybe including it in the future articles of association, share purchase agreements, or shareholder agreements. And in this respect, Valts, can you share please some tips with our listeners? How would you approach that? What do you recommend them when they are considering conclusion of an arbitration agreement with respect to corporate disputes?
There are many aspects, but I would just cover perhaps one angle. And well, I'm a fan of private international law, and I have seen so many cases, so many questions, and so many questions answered wrongfully when it comes to applicable law issues. So I can just remind everyone that arbitration agreement is a separate agreement from the framework agreement in which you have the arbitration agreement, which means that unless you have agreed on the applicable law to arbitration agreement, there is always this guessing game about which law governs the arbitration agreement. Of course, when there is no foreign element, you have everything located in the same country. There shouldn't be any doubt about the applicable law. But nevertheless, technically, I mean, you could try to have a contract between, local parties from the same country with an arbitration in the same country institutional court of arbitration, but have this arbitration agreement governed by, some corporate dispute friendly law, such as, I don't know, could be a wild guess about Austrian, Italian, or Spanish law. It of course depends on your research, but it would absolutely give you an advantage that, well, the parties are free to agree, and the parties have agreed that this kind of dispute can be arbitrable. At the end, of course, we can end up at what the law of the sea says, or lex arbitra in this case, about whether the dispute is arbitrable or not, and also what the law of the place of enforcement says about the arbitrability of this kind of dispute. But getting the applicable law things right is the homework that I see that the parties do not do. And should the parties have done it more often, I mean, it would also give much more clarity at the very beginning, before the dispute actually arises, whether in future this dispute could be arbitrable or not. And then we also can discuss a lot about whether or not to choose Latvia or any of the Baltic states as a seat for arbitration, or whether or not just to turn this dispute to international arbitration with a seat, in Sweden, and just forget about all this. But yeah, well, I have been talking too much, so yeah, I give the floor to my colleagues now.
Not all, Alex. Thank you for your valuable tips. Raul, what can you recommend?
Thank you, Aliaksei. To me, when I consider this topic, an interesting thought comes to my mind. In legal community or legal theory, the jurisdiction clauses are often called as midnight clauses. And what it means that it's very often that parties kind of forget to think about at the jurisdiction clause, and it will be late at night at the very end of the negotiation. You just got over with important, substantial agreements. You feel like, okay, we found an agreement. There's nothing that could go wrong now. Let's not gonna worry about the dispute resolution clause. And usually that's where the problems arise, because in practice, it very often is that many issues could have been resolved beforehand, and it would have made the later dispute much more speedy and straightforward. The less issues you have, the cheaper and straightforward the dispute later is. So as Valts already said, I would very much encourage to think about the jurisdiction clause and include a professional advisor in order to consider that. But just few thoughts of what to think about is that in order to arbitrate, you need a consent of all parties. So make sure that everybody has give either signature or any other form declaration of intent that they wish to be bound by this arbitration agreement. And this comes quite difficult with the articles of associations, where you cannot really ensure that every new party or shareholder is agreeing with the articles of association. So in order to do that, you need a separate agreement that the new shareholder who joined the party or who joined the company agrees with the existing arbitration clause. Otherwise, it's quite impossible to apply this agreement to this new party. And I know Ieva has some interesting thoughts about third-party arbitration clauses. This is something also that should be considered, that arbitration clause could and should be wider if there's a risk that there are multiple parties within the arbitration. But that's it for me as well now. Thank you.
Well, thank you. Yeah. Thank you, Raul. Yes, I think these type of disputes that we discussed today is most of the time they are multi-party disputes, and sometimes the simple modal clauses given to us as an examples by major arbitration institutions might seem not enough. They do not reflect the specifics of such disputes. So I know that there are already certain arbitration institutions that provide the model arbitration clause to be used to multi-party arbitration. So I definitely encourage in this kind of circumstances to use it. If needed, we will help you to find that. Also, I would totally agree with Raul and Valts that the well-written arbitration clause is a first step to successful arbitration. When we talked about the benefits of arbitration, so we discussed the time and cost issues. So this is directly reflected to these issues, because if we have certain things not being discussed in arbitration clause and not agreed by the parties, most of the time after the dispute has already arisen, there's very hard debates about that, and this takes time, and of course that costs money. So that's just from the general side, and from the particulars of Lithuanian law. I think I would have two tips. First of all, if after creation of articles of association, which encompass these arbitration clauses, the composition of shareholders or management bodies change, do not forget to sign some additional document agreement indicating this their will and consent to undertake to act under these articles of association and be bound by this arbitration clause. Because as we know and we discussed from the case law, this is the main issue that is being considered by the courts. And in case one would decide to refer disputes with the manager to arbitration as well, so do not forget to sign a separate agreement from the employment agreement, clearly indicating which type of disputes would be referred to arbitration and separating it from the employment sphere. So I think that would be my tips from Lithuanian perspective.
Thank you. Thank you a lot. And I believe it concludes the questions that I have, but we have a couple of questions from the audience. And before we proceed with them, I would like to kindly remind our listeners that you still have an opportunity to post your question using the Q&A function. And now, the first question from the audience, a wonderful question from Raul. Apologies if I have mispronounced your name. It basically is a great question that causes a significant debate in all the countries that are considering more wide use of arbitration for resolving different kinds of corporate disputes. And this question has two parts. The first one basically concerns arbitration agreement in public companies and consent of all the shareholders to them. How can we ensure that all the shareholders actually agree to the arbitration agreement, including in the articles of association? And should we actually have maybe some special rules for public companies to account for that? Yes, once please.
Yes, yes. Hello, Raul. Thank you for your question, and I agree with your thoughts. And this would be my understanding under Latvian law that challenging this corporate value decision shouldn't be arbitrable. Exactly, because I think of the public interest and it should be the competence of the state courts and they remain such. Also, well, because of the certain functions of the commercial registry and the public element of the decisions and that they must be registered. I think this just corresponds with the Latvian law understanding. The cost element that you mentioned is, of course, important. I wouldn't say that this could be decisive, but still, I think, well, for me, it just makes sense that some corporate disputes should be arbitrable and some not. And that these body decisions, I think, well, I would say currently, no, at least from the Latvian perspective. Thank you.
Yes, limiting of arbitrability is one of the solutions, but maybe some of our other speakers, Raul, Ieva, support some other measures, maybe procedural measures like those that exist in Germany, or maybe some special arbitration procedures simplified, ensuring that there are lower costs for all the shareholders in public companies. What do you think?
All right, I can share my thoughts on the issue. Honestly, I don't really see how public limited company could have its disputes arbitrated because of the great public interest and the need to defend the minority shareholders' interests. And I think it comes from the NASDAQ or the public shareholders rules issued in the business laws of Estonia. So when speaking about articles of associations and arbitration clause within there, I'm only considering private public companies or private limited companies, sorry, where the shares are not listed publicly. Otherwise, it could be almost impossible to get their all consents unless there's great legislative changes, at least in Estonian law. But yeah, Ieva, you could share your thoughts.
Yeah, I think I would agree with both of you. I'm not aware of any case law in Lithuania on this matter, so I think there would be definitely an issue, and interesting to see how the court would proceed with that. With respect to a voluntary choice, Ieva mentioned, I would say that, well, I wouldn't say that it's not possible to express this voluntary choice. I think that's the question of the form, and also about the proceedings where there are more or less like more shareholders, for example, multiple parties. I see in the practice, I think from Germany, that the most important thing that they would be aware of the dispute and basically have a chance to participate therein. So if these opportunities are given, there shouldn't be a problem. But of course, there are not many regulations in Lithuania with this matter, and it's still a lot to be developed yet.
I would just add one sentence that I think the problem lies that that kind of dispute, challenging decision of a corporate body, is not itself a contractual dispute. And I think it just answers the question about its arbitrability. Because should it be a contractual dispute, I think we would answer in affirmative that type of dispute could be arbitrable. But here I just wouldn't see this contractual element, and to me it just doesn't sound right to arbitrate that kind of disputes. Yeah, thanks.
Okay, it looks that we will need significant development of arbitration practice in all three Baltic states before we actually come to see any arbitration of corporate disputes in public companies. But hopefully we will see it sooner than later. And we have a couple of additional questions. One is, what is the average timing for arbitration proceedings in each of the jurisdictions? Ieva, could you please start with Lithuania?
I think I already mentioned that, but it's around 8 months, I would say. Yeah, the reasons. Yeah.
How's it in Latvia?
8 is a good number. I would say, I don't know, 5 to 8, probably, but it's quite effective. Yeah.
Raul, would you go with 8 or some different number?
Under the Estonian courts, arbitration courts regulation, they need to resolve the dispute within 6 months from the date the arbitral tribunal gets the file. So usually what we see is from the date the dispute arises, the client comes to us. It takes usually 12 months to get it all resolved. And I mean forming the tribunal, having the dispute itself, and then going to the enforcement stage. So 9 months to 12 months would be my answer with respect to Estonia.
Thank you. So we have another question from Kairi Lang. Once again, sorry if I mispronounce it. And Raul, you have mentioned previously that in Estonia, arbitral awards are immediately enforceable. So Kairi would like to clarify how the situation in Lithuania and Latvia. I believe it is not the case, but Valts and Ieva, please feel free to confirm or say something else.
Indeed, I actually must admit I had missed this absolutely super advantage of Estonian law. I mean, this is so cool that indeed you have this in Estonia, and unfortunately we don't have this in Latvia. As for the reasons as I explained before, I mean, the perception of arbitration is changing, and we are getting there with the ancestral model law as it should be in the civilized world and so on. But this is a process, and we're still getting there. As I mentioned, we have currently 57 arbitration courts about the impartiality of all of which I wouldn't be absolutely sure, to put it short. And therefore, I mean, we are not there yet. I could imagine listing, I mean, 5, perhaps up to 5 of these 57 arbitration courts, to whom I would say, yes, these awards should be enforced immediately, same as Estonia. But we can't have, you know, this selection on basis of what principles. So unfortunately we still have to go through the enforcement proceedings at Latvian courts, but they are relatively fast, so to say. I mean, you could get the decisions into instance courts within a year. I hope so.
From the Lithuanian perspective, I would say, yeah, it's more than in Latvia. Estonia seems really good, and I will definitely take this into account when choosing the place for arbitration. And I would say, yeah, we also have the process of recognition and enforcement, but compared to Latvia, I would say that this is when comparably shorter. This is like 3 or 4 months if there are no disputes. So you still have to have formal procedure, but sometimes it takes even 2 months. So it depends, but it's not a year. Of course, if we have challenging of the decision, that might be longer, but still like up to a year.
Thank you, Ieva and Valts. And I believe it would be great to conclude this discussion with the last question. Would you recommend your clients local or international arbitration? Raul, could you please comment on that?
Of course, I could. As we just finished with the topic of Estonia, Estonia's benefit to the award being immediately enforceable, then I would recommend for at least Estonian companies to have their disputes within Estonian Arbitration Court in the Civil Chamber of Commerce and Industry. But with disputes having an international element with disputes with international element, we would usually recommend, we are recommending Stockholm or Helsinki. And these judgments are also quite clear, and there's no issue with enforcing them in Estonia as well, although they are not directly enforceable. It's just the institution itself is more well known. The support from the institution in Stockholm and Helsinki is better than in Estonia, at least in usual cases. So it depends on the cases, as usually with every answer with lawyers, but yeah, both are fine actually. Thank you.
Yeah, so definitely this depends on all kinds of circumstances, and every time on case by case we consider this issue. So I would say I have my total confidence into arbitration institution in Vilnius, Vilnius Court of Commercial Arbitration. From practice we had, we were definitely happy with it. Of course, there are certain international disputes where basically the other party would not even consider in negotiations the local institutions. So then we have international arbitration institutions, and I think the priority that the international arbitration institutions have is the pool of arbitrators that would be willing to join the proceedings and to decide on the case. And the priority of the local institution is always the costs. So that should be weighed and considered in the process of choosing. Thank you.
Yes, I would start with that. The Baltic countries were small countries with small market. All the Baltic economies combined is half of the Finnish economy, to give an example. We're small companies and we have small disputes. Small disputes in the international arbitration scale, I mean, below 5 million euros, to say at least. And therefore, I think it boils down to the cost, actually, of getting your dispute arbitrated. If your dispute is expected to be 5 million, or if your company is really into that scale of business, I think you should absolutely consider whether or not having indeed your disputes arbitrated in an international arbitration institution. Bearing in mind all the costs, all the support, all the advantages, as Raul mentioned, and Ieva, but still, we are small. And therefore, also I would be pretty confident in saying that I also have all trust in the Arbitration Court of Latvian Commerce and Industry, Chamber of Commerce and Industry, and therefore I believe that the corporate disputes can be successfully arbitrated there as well for local companies with perhaps not that big disputes, not that huge revenue and then market share in general. But other than that, of course, international arbitration would give you more security. As I mentioned before, you can also play with the applicable law, meaning that this is the party's free choice. You can improve your position by perhaps agreeing on the right seat. Well, you have several options, of course. One is the applicable law, second is the arbitration institution, then you have the seat, and so on. So there are different components that you can put in your future, in your arbitration clause for your future disputes. And having said that, if you have a mindful choice, then you can have your corporate dispute arbitrated safely for adequate cost with a predictable outcome, hopefully. And that's what I wish for all the participants. Thank you.
It's hard to disagree with that. And thank you to our speakers, and big thanks to our wonderful audience for being with us during this webinar. Hope you like it, and if you still have some questions or issues and answers, please, and it also will be available on our YouTube channel. Feel free to subscribe to it. You will find there not only this recording, but also recordings of other great webinars with legal advice. Thank you once again, and see you at our upcoming events. Have a nice day.